Well, PPS stands for Personal Property Securities Reform. One of the difficulties, people look at the title and they see personal properties and they think it just refers to dealing with customers. So they think it doesn't apply to them. Then they look and see that it applies to something called securities, and they think it just deals with taking security over things. So they think it doesn't apply to them. But it applies to a wide variety of businesses, virtually every transaction you can think of, where people are dealing with each other in personal property. That's everything other than land. Shares, ships, planes, cars, interests in bonds, securities, intellectual property, everything. What the reform tries to do is to make it easier for people when they're taking security over assets from each other. And taking security means whenever they're dealing with assets and one person wants to look at the asset as being a way in which it can get recourse for obligations. It's not only limited to mortgages and charges, it includes all sorts of arrangements. Like if I'm lending you a scaffolding for a while, that can become a security interest. If I have a repo with you under which you and I exchange shares for money, depending on the way the regulation goes, that could be a security interest. Well, it's already enacted and it comes in May 2011. There'll be further amendments and regulations to come. Some people think that's a long way off, but if you work backwards, if you're a financial institution and if you haven't started, it's already too late. And a lot of other people need to think very hard about the systems that they need to introduce and the documents they need to introduce and the way in which it will affect the ways they carry on business. If they're borrowers, they need to think about their negative pledges. If they supply a lot of goods on retention of title terms, they need to think about a few things. They need to think about their standard terms, but they also need to think about the systems they have for dealing with all the obligations they'll have under the statute, because they can be required to provide a lot of information at very short notice and to deal with claims at very short notice. In New Zealand, they've learned to live with it. They find it fairly easy to deal with, but there are still a lot of uncertainties and a lot of the issues are still being worked out. The difference between Australia and New Zealand is that in New Zealand, if you haven't registered something, if you haven't registered a security interest or perfected it, you can still have a good security against a liquidator. In Australia, if you haven't perfected your security interest and the charge-or goes into liquidation, or the charge-or goes into voluntary administration, or the charge-or goes into bankruptcy, you lose your security interest. So unless you register, you lose. Probably the last exercise with such a major piece of legislation, and remember this piece of legislation is 320 pages long and over 340 sections, was the FSR, the Financial Services Reform legislation. But that's different. That was a lot of regulations which really set out the public duties of people and was all subject to review and waiver and modification by the regulator. This doesn't really have a regulator apart from the registrar. This sets out clear private rights between people. There won't be the opportunity to go back to the regulator and say we got it wrong. You'll either have a good security interest or you won't. You'll either have priority or you won't, and no regulator can make that right for you. So it's important to get that right. What this legislation is designed to achieve is to get rid of a whole raft, about 70 or 80 different pieces of legislation across the states and territories and across the Commonwealth, which regulated security interests in some way. Different registration systems, different formal requirements, different ways of judging priority. All of those get replaced by one piece of legislation which says it is simple but in many ways is complex. It does establish a new electronic register which is very easy to use, but there are an awful lot of uncertainties and difficulties in the way that the legislation works. The biggest weakness of the legislation is its complexity and its inflexibility. Once, although we had a lot of different pieces of legislation dealing with the registration of security interests, basically we had a few principles-based rules as to how things would work. Now we have 320 pages of legislation which are quite detailed and quite specific rules. And sometimes they will have effects that are quite counterintuitive. And it's not easy sometimes to see the overall principles, so you can be caught up in all sorts of surprising ways. and it may change the way in which a number of standard transactions work. And as the courts get to grips with it, we may be surprised in 20 years or 25 years' time, or even a couple of years' time. You can't accept the whole lot of things for granted the way you used to. Well, under the PPS legislation, if you don't register your security interest, or you haven't perfected it by some other means, then you can lose the entire thing. You lose your interest in whatever asset you had. And the difficulty there is, it's not always clear what is a security interest. And sometimes you can have things that are security interests, or could be held by the courts to be security interests, which you wouldn't normally think of as being a security interest. For instance, a scaffolding supply company can have a security interest over its letting of scaffolding to its customers, even though they've got nothing to do with security. A flawed asset arrangement with a bank can be regarded as a security interest, even though it's got nothing to do with security. An assignment of a debt can be a security interest, even though it's got nothing to do with security. There are a whole lot of transactions that now aren't really affected by the law relating to security interests that now will be.